Many people in Ontario spend their lives working hard to take care of themselves and their families, but we often overlook and delay making plans to take care of our loved ones after we're gone. Whether you're planning for your family's future after your passing, or you may be financially affected by someone else's passing, it's important to understand a little bit about estate law. In this video, we'll look at the top 5 questions people have about wills and estate law in Ontario. Question 1. What is a will and what happens if I die without making one? A will is a legal document that says who gets your property after you die. The property you own when you die is called your estate. A will is sometimes called a last will and testament. The person making a will is called a testator. If you have a spouse, you cannot make one will for both of you. You must each make your own will. It's usually a good idea to make a will whether or not you're married, have children, or have many assets. You might think you don't need a will if you don't own a house, don't have much money, or don't care who gets your property. But someone will have to arrange your funeral, pay your debts, and file your final tax returns. When you make a will, you decide your estate trustee, who is the person you trust to carry out the directions in your will. Your beneficiaries, who are the people and organizations you want to leave your property to. Who will take care of your children under the age of 18. Who will manage the property you left for your children under the age of 18. Who you want to give specific property, like jewelry or a car that may be of value or have sentimental value to you. What you want to happen at your funeral. If you die without a will, Ontario law has rules about who gets the property in your estate. These are called the intestacy rules. Under these rules, people who you thought would get your property may get less or more than you wanted them to get, or they may get nothing. For example, the intestacy rules say only a legally married spouse and biological and adopted children have a right to your property. The intestacy rules do not give anything to a common law partner or to stepchildren you haven't legally adopted. Question 2. What are probate fees and can I reduce them? Probate fees, also called estate administration tax, are fees that are paid to the Ontario government. The amount of the fee is based on the total value of the property in your estate when you die. The less property you have in your estate when you die, the lower your probate fees. In Ontario, probate fees are $5 for every $1,000 of assets up to $50,000 and $15 on every $1,000 of assets over $50,000. Your estate is the property you own when you die. This includes real property in Ontario, such as land and buildings. It also includes personal property such as jewelry, furniture, investments, and bank accounts. There are ways to deal with your property that can reduce your probate fees. For example, you can give gifts to people and organizations while you're alive, have a designated beneficiary on investments such as life insurance policy, benefits plan, and registered plans such as a registered retirement savings plan, RRSPs, or tax-free savings accounts, TFSAs, or own property with someone else jointly. These assets don't form part of your estate when you die and are not included when calculating probate fees. They pass outside the will. This means they are not affected by your will or the intestacy rules. Alter ego trusts and joint partner trusts are other ways to reduce probate fees. These are more complicated to set up and usually require legal help. Question 3. What do I need to think about when making a will? We already mentioned in the answer to question 1 about some of the things you will decide in your will, but we'll expand on that in this question. To make a will, you must be mentally capable. This means that you understand why you are making a will, how much property you have, and which of your dependents should be included as beneficiaries. Your will may be challenged if you make it when you're not mentally capable or if you don't include dependents. A dependent is a person you were supporting financially before you died, or a person the law says you must support. You must also be at least 18 years old to make a will, but you can be younger than 18 if you're legally married, a member of the Canadian Armed Forces, or a sailor. Question 4. I'm married. What happens if I die without a will? If you die without a will, Ontario law has rules about what happens to the property in your estate. These are called the intestacy rules. Under the intestacy rules, who gets your property depends on whether you're married or not married, and how many children you have. The intestacy rules say only a legally married spouse and biological and adopted children have a right to your property. The intestacy rules do not give anything to a common law partner or stepchildren you haven't legally adopted. If you're married and do not have children, then your estate goes to your spouse. This includes a spouse you separated from but have not divorced. If you're married and you do have children and your estate is worth less than $200,000, then your spouse gets everything. If your estate is worth more than $200,000, your spouse gets the first $200,000 and the rest is divided between your spouse and children. If you're not married and you don't have children, your estate goes to your living closest relatives. If you have no relatives, your estate goes to the Ontario government. If you're not married, but you have children, your children share your estate equally. Question 5. What can I do if someone died and I don't agree with what I'm getting from the estate? If someone died and didn't leave you anything or as much as you think they should have, or if you're not entitled to anything under the intestacy rules, you might be able to make a claim against their estate or challenge the will. There are two main kinds of claims that can be made against the estate of someone who died: a dependent support claim and an equalization claim. A dependent support claim means asking the court for support from the estate because you were dependent on the person who died. A dependent is a person who was supported financially by the person who died, or a person the law says must be supported by the person who died. This includes a married or common law partner, child, stepchild, grandchild, parent, grandparent, brother, or sister. It can even include a divorced ex-spouse if you were still being supported by the person when they died. You might also be able to make this claim if the person died without a will and you're a common law partner or stepchild who was not legally adopted. This is because the intestacy rules do not give anything to a common law partner or to stepchildren who were not legally adopted. In an equalization claim, your spouse can decide whether they want to take what they are entitled to under the intestacy rules, or they can choose to get an equalization payment. Common law partners and divorced ex-spouses can't make an equalization claim. You calculate the equalization payment as if you and your partner had separated and divided your property. But there are a few special rules on how to calculate equalization after one married partner dies. If you separated before your married partner died, you value property on the date you separated. But if you were not separated when your married partner died, you value property on the day before your married partner died. There are also some special rules on how to calculate the equalization payment if your partner left gifts for you in their will. Depending on what the will says, you might get these gifts in addition to an equalization payment. If you want to get an equalization payment, you must take legal steps within 6 months of your partner's death. Sometimes the court allows more time. There is a special form you need to fill out to tell the court that you would like to get equalization. A lawyer can help you start a court case if you want to get an equalization payment. We mentioned earlier that it's possible to challenge a will. You might be able to challenge the will if you think it isn't valid. A will may not be valid for many reasons. For example, it won't be valid if when making the will, the person who died wasn't mentally capable, was under too much pressure to sign the will, for example, from a family member, or didn't follow the rules for making a will. If a court decides the will isn't valid, then the estate is not divided according to the will. Instead, it is divided using the intestacy rules. You have to go to court to make a claim or challenge a will. This can cost a lot of money and take a long time, and it can be very complicated if you decide to make more than one type of claim. It's a good idea to get help from estate lawyers. A lawyer can discuss your options with you, tell you if they think you can be successful, and help you through the process. A lawyer can also make sure that you don't miss deadlines to make any of these claims. Please note that this video is intended for general illustrative purposes only. This video is not intended as legal advice, and we strongly recommend consulting a qualified estate lawyer before making any decisions that could affect your rights. If you found this video helpful, please take a moment to subscribe to our channel and leave a comment with a topic that you'd like us to make a video about. You can also support our efforts to make free legal information available to Canadians by supporting KBA Lawyers on Patreon.